You have the right to remain silent. You've heard those words 1,000 times. Every cop show, every crime movie, every legal drama that's ever aired on television. They're so familiar, they've become background noise. But here's what most people don't know. Those words almost didn't exist. There was no legal requirement to say them until 1966. And the man whose name is on the Supreme Court decision, the man who made those words the law of the land, was convicted anyway. Retried without his confession, convicted again on other evidence, paroled in 1972, and stabbed to death in a Phoenix bar 4 years later.
Jesus Christ.
And in the twist nobody could have scripted, the suspect in his murder invoked the very rights that bore his name, and was never brought to justice. That's the Fifth Amendment, and it goes a lot deeper than one warning. Let's get into it. All right, if you're new here, I'm JP. I'm a former Special Forces officer with 14 years of service, having deployed to 11 countries across 3 continents. In the environments I've operated in, the rights we're talking about today didn't exist for most people. No right to silence, no protection from being compelled to testify against yourself, and no due process before the government took your life, your freedom, or your property. The Fifth Amendment is the wall between that world and this one. And understanding exactly what's behind that wall matters more than most people realize. Here we go.
Hold on to your butts.
The text, here it is in full. No person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. 108 words, 5 completely separate rights packed into a single amendment. Let's break those down quickly. 1. The grand jury clause. Most serious federal crimes must be charged by a grand jury, not just a prosecutor acting alone. 2. A double jeopardy. You cannot be tried twice for the same crime after an acquittal. 3. Self-incrimination. You cannot be forced to testify against yourself. 4. Due process. The government cannot take your life, liberty, or property without fair legal procedures. 5. The takings clause. If the government takes your private property for public use, it must pay you a fair market value. 5 rights, 1 amendment, and they all have a story. Today, we're going deep on 3 of them. The ones that show up most in real life, in courtrooms, and in headlines. And then we'll briefly touch on the other 2. But first, we need to go back to where it all began. All right, we're in Phoenix, Arizona, March 13th, 1963. Ernesto Miranda is a 22-year-old. He's brought to a police station and placed in a lineup and identified as a suspect in the kidnapping and rape of an 18-year-old woman. Then, 2 officers take him to Interrogation Room No. 2. 2 hours later, they walk out with a signed written confession. Miranda was never told he had the right to stay silent, never told he could have had a lawyer present. The confession form he signed stated it was made voluntarily and with full knowledge of his legal rights. But no one had told him what those rights were.
You're supposed to say, I have the right to remain silent. Nobody said I have the right to remain silent.
He was convicted, sentenced to 20 to 30 years, and in about 2 minutes, I'm going to show you how that case didn't just change Ernesto Miranda's life, it changed the rules for every single arrest made in America from 1966 and forward. But to understand why Miranda matters so much, you need to understand where the Fifth Amendment came from in the first place. The right against self-incrimination has roots that go back centuries before America existed. In 16th and 17th century England, the crown operated a court called the Star Chamber, an instrument of royal power that could haul anyone before it, demand they swear an oath to tell the truth, and then question them about their beliefs, associations, and loyalty to the crown. Refuse to swear the oath? Punishment. Answer honestly? Potentially execution. It was a trap with no exit. The English common law tradition slowly built a wall against this. By the late 1600s, the principle that no man should be compelled to be his own accuser was established in English law. The American founders took that principle and codified it in the Fifth Amendment. They had watched the British use legal process as a weapon against colonists, demanding testimony, compelling confessions, using the courts as an instrument of intimidation. They built protections against every version of it they could imagine. What they couldn't imagine was a world of professional police forces, isolated interrogation rooms, and psychological pressure tactics refined over 2 centuries. That's the world Ernesto Miranda walked into in 1963. And what the Supreme Court decided about his case 3 years later is one of the most consequential rulings in American legal history. The Fifth Amendment has generated an enormous body of case law. I'm going to walk you through the cases that matter most, organized around the 3 provisions that affect everyday Americans most directly. Self-incrimination, Miranda versus Arizona, 1966. Back to Phoenix. After the Arizona Supreme Court upheld Miranda's conviction, his case went to the U.S. Supreme Court, bundled with 3 similar cases from other states, all involving confessions obtained without informing suspects of their rights. In a 5-4 decision, Chief Justice Earl Warren wrote one of the most consequential opinions in court history. The ruling was sweeping. The Fifth Amendment's protection against self-incrimination doesn't stop at the courtroom door. It applies the moment you are taken into custody. The inherent pressure of a police interrogation, isolated, intimidating, controlled entirely by law enforcement, is coercive by nature.
Knock it off. Okay, I'm interviewing you.
No, you said that I'd be conducting the interview when I walked in here. Now, exactly how much pot did you smoke?
Without being told your rights, you cannot meaningfully choose to waive them.
Do you even know the Miranda rights?
Yes.
Let's hear them then.
You got a lot of stuff to do.
Go ahead.
You got a lot of...
The remedy? Before any custodial interrogation, police must inform suspects that they have the right to remain silent, that anything they say can be used against them in court, that they have the right to an attorney, and that if they can't afford one will be appointed. Those 4 sentences became the Miranda warning. They've been read at every arrest in America for nearly 60 years. Here's the twist nobody tells you. Miranda himself was retried without his confession and convicted again on other evidence. He went to prison anyway. He was paroled in 1972, spent his last years signing Miranda warning cards for $1.50 each, and then stabbed to death in a bar in 1976. The suspect in his burner was read his Miranda rights and was never prosecuted. Next, double jeopardy. What most people get wrong. The double jeopardy clause says you can't be tried twice for the same offense after an acquittal. Most people think this means if you're found not guilty, you're untouchable forever. That's not quite right. First, double jeopardy only attaches after a jury is sworn in or the first witness is sworn. A dismissed charge before trial begins doesn't count. Second, and this is the part that surprises most people, the federal government and state governments are considered separate sovereigns. If you're acquitted in a state court, the federal government can still charge you for the same conduct under federal law. This is called the dual sovereignty doctrine, and the Supreme Court has upheld it repeatedly. You've probably seen this play out in high-profile cases where someone is acquitted at the state level and then faces federal civil rights charges. That's not a double jeopardy violation. That's dual sovereignty. Due process, the clause that does everything. The due process clause is the most expansive provision in the Fifth Amendment, and arguably in the entire Bill of Rights. At its most basic, it means the government must follow fair procedures before taking your life, liberty, or property. But the Supreme Court has interpreted it to mean much more than that. Procedural due process covers the mechanics. You get a notice, you get a hearing, you get a chance to respond before the government acts against you. Substantive due process goes further. It holds that certain fundamental rights are so deeply embedded in American liberty that the government cannot infringe them at all, regardless of what procedures it follows. This doctrine has been used to protect everything from the right to marry, to the right to contraception, to, until recently, the right to abortion. Here's something most Americans don't know. Due process doesn't say citizens, it says persons. The Supreme Court has consistently held that the due process protections of the 5th and 14th Amendments apply to every person on US soil, citizens, legal residents, and undocumented immigrants alike. That's not a loophole or a modern interpretation. That's what the text says, and the courts have affirmed it repeatedly. It's one of the most significant and least understood facts about the Bill of Rights. The 5th Amendment's due process clause applies to the federal government. The 14th Amendment extended an identical clause to the states. Together, they form a constitutional backbone of individual rights against government overreach. All right, grand juries, the gatekeepers nobody talks about. Before the federal government can charge you with a serious crime, it has to convince a panel of 23 ordinary citizens that there's enough evidence to proceed. The idea was to put civilian check between the prosecutor and the accused. In practice, grand juries approve the vast majority of indictments brought to them. Proceedings are secret, one-sided, and the standard is just probable cause. There's a famous legal saying, a good prosecutor could indict a ham sandwich.
What?
Worth knowing, this clause only applies to federal prosecutions. States are not required to use grand juries, and about half don't. All right, finally, the takings clause. Your property and the government. The last provision is the one most people encounter, not in the courtroom, but in their neighborhood. The takings clause says the government can seize your private property for public use, but it must pay you just compensation. This power is called eminent domain. It's how governments build highways, schools, and public infrastructure. And for most of American history, it was relatively uncontroversial. The government took land for genuinely public purposes. Then came Kelo versus City of New London in 2005. The Supreme Court ruled 5-4 that local governments could use eminent domain to transfer private homes to private developers, if the economic development served a broad public benefit. In plain terms, the city could take your house and hand it to a corporation. The public backlash was massive and crossed every political line. Within a few years, 44 states passed laws restricting eminent domain beyond what Kelo had allowed. It remains one of the most unpopular Supreme Court decisions of the modern era. Where it shows up, invoking the Fifth.
I wish to assert my Fifth Amendment privilege.
And then there's the public version of the Fifth Amendment, the one you see on television and in congressional hearings. You always see them sitting there as they're being questioned. I respectfully decline to answer on the grounds that it may tend to incriminate me. Anyone can invoke it. Mob bosses have used it. Wall Street executives have used it. Politicians have used it. Civil rights activists used it during the McCarthy era to refuse to name names to the House Un-American Activities Committee. O.J. Simpson's civil trial is a good example of how it plays out. After his criminal acquittal, Simpson was sued in civil court. He invoked the Fifth repeatedly when asked questions that could have exposed him to further legal jeopardy. The right that was built to protect the powerless from the state is available to everyone, regardless of who they are or what they're accused of. That's not a flaw in the system. That's the point of the system. One important limit: invoking the Fifth in a civil case can be held against you. A jury in a civil proceeding is allowed to draw an adverse inference from your silence. The protection is strongest, absolute in fact, in criminal proceedings. All right, let's talk about what two of these look like in practice. Miranda warnings have been read at virtually every custodial arrest in America since 1966. That's hundreds of millions of warnings over 6 decades. And yet research consistently shows that most people waive their Miranda rights and talk to the police anyways. A 2017 study published in a journal Law and Human Behavior found that approximately 78% of suspects waive their Miranda rights and submit to interrogation. The researchers found that many people, particularly younger suspects and those of lower education levels, don't fully understand what they're waiving. That creates a paradox the courts have never fully resolved. The warning exists to ensure informed choice, but research suggests the choice often isn't as informed as the system assumes it is. When it comes to double jeopardy, the dual sovereignty doctrine has been applied in some of the most high-profile criminal cases in American history. Federal civil rights charges following state acquittals have been brought in cases involving police use of force, where the state juries acquitted but federal prosecutors pursued separate charges. The Supreme Court reaffirmed the doctrine as recently as 2019 in Gamble versus United States. This one amendment has 5 rights, and every single one of them is still being fought for in the courts today. So here's where we are. The Fifth Amendment's 5 protections are all still active, but they look different in practice than most people imagine. Miranda warnings are required, but waiving them is common and legal. Grand juries are required for federal felonies, but they operate in secret and approve the vast majority of indictment prosecutors bring to them. Double jeopardy protects you from being retried after an acquittal, but dual sovereignty means the federal government and the state government can both take a swing at you. Due process guarantees fair procedures and protects fundamental rights, but exactly which rights are fundamental is the question the courts continue to answer and re-answer. And the Takings Clause protects your property, but the definition of public use has been stretched far beyond what most people would expect. What I'd ask you to take away from this episode is this: the Fifth Amendment was built on a single foundational idea, that the government's power to investigate, prosecute, and punish must have limits, and no person should be a weapon against themselves. That the state must play by the rules, whether those rules are strong enough, whether they're applied fairly, and whether they keep pace with the world we actually live in. Those are the questions every generation of Americans have had to wrestle with. This one is no different. All right, if this was useful, please subscribe, because next episode, we're into the Sixth Amendment, the right to a speedy trial, a public trial, an impartial trial, and the right to confront your accusers. It's the amendment that defines what a fair criminal trial actually looks like in America. And there's more at stake in it than most people realize.
Did you order the code red? You're goddamn right I did!
I'll see you then.